All right, I want to welcome everyone to our April 2022 Luncheon Lab on protecting your brand. I'm really excited that you all could be here. Feel free to put your questions in the chat. We'll have some question and answer at the end of our presentation. I'm very excited to be joined by my two special guests today, Phyllis Simon, who is with Simon Law, and Roland Senholz of Ardent Place Law. So I'm Reggie Holmes. I'm the host of this Lunch and Learn, our Luncheon Lab, and I'm the founder and creative director with Enthuse Creative, and I help businesses to build their visual and verbal brand, if you will, to develop the creative and assets and the messaging that helps communicate their brand's value to their audience. So I work on the creative side of branding, and Phyllis and Roland work on the legal side. So I will allow each of them to introduce themselves at this time.
Hi, my name's Phyllis Simon. I'm a solo practitioner. My firm is Simon Law. And the mission of my practice is to help small businesses understand trademarks, copyrights, and patents.
Excellent. Roland?
And I'm Roland Senholz with Ardent Place Law, and we try to make things as painless as possible for entrepreneurs, for people who are looking to build something bigger than themselves. We can help them with setting up their company, getting their contracts handled, all of that kind of stuff. So yeah, looking forward to this.
Great. And thank you both again for being. Our takeaways are we're going to learn about intellectual property and how to protect your brand. You'll see that again on a future slide. So the disclaimer is that while Roland and Phyllis are both attorneys, nothing here should be interpreted as legal advice. This presentation is intended to help you understand the basics of intellectual property law and facilitate discussion with the attorney of your choice. So they are not here to market their services. They're simply here to provide information, and you can make a choice in who you have represent you in intellectual property matters in the future. So that this does not intended to communicate any attorney-client privilege. So just want to put that out there as a disclaimer, and we'll continue. I will share my personal intellectual property protecting your brand story. So a few years ago, pardon me, I started my business in 2013, and I was a independent graphic design firm, and I wanted to pursue obtaining a trademark as early as possible, but I honestly thought that it was something that I could just sort of do when I had made a certain amount of money, or when I guess got to a certain level. And so it was only about 5 years into business that I really felt like, okay, I should start really thinking about that. And I figured, I had a somewhat unique name, although there are a lot of creative agencies, marketing firms out there. I decided to start the process of filing it in 2019. And full disclosure, I work with Roland and his firm to be able to do that. And so even though I had opened my business first, there was another company with a similar name. And I was not able to obtain the trademark that I filed for because they had actually gone through the process of filing prior to me filing. And even though I had a company that existed before then, in between that time of starting and sort of getting ramped up, they had actually filed for the trademark. So I was not first in line, I was second. So it was denied, my application, based on being deemed too similar and likely to cause confusion. This company was in marketing. We did some different things, but they were essentially a marketing company. And so they, it was denied. So what I had to do was work with Roland to reach out to the other company over a period of months to draft a coexistence agreement. And that allowed, each of us to have our separate trademarks, but kind of with some parameters put in place to understand what we do differently, what they do differently, and an agreement to sort of have some space to limit that confusion. And so the trademark was recently published and should be awarded soon. But I feel like my story is probably my thought process, which was erroneous, was probably like a lot of small businesses who think that maybe a trademark is something that they can push down the road, or, it's a priority, but maybe not a high priority. They don't necessarily know when to go about that process. And then it can be, either too late, or they run into some challenges that they didn't anticipate. So I feel like my story is more common than not. And one of the reasons why I wanted to do this particular luncheon lab was to provide just some great information for the small business community to be able to make their own decisions about trademark, but to really trademark and other intellectual property, honestly, that has to do with their brand, and just be equipped with that information to be able to make the best decision for their business. And so I wanted to bring in some experts to provide us that information. And Phyllis is going to be coming up first and talk about one particular dimension of IP, which is patents. So with that, I will turn it over to Phyllis, who will jump in to our talk on intellectual property.
Thanks, Reggie, for hosting this and for sharing your story on registering your trademark. So the thing about intellectual property is every business has intellectual property, and some individuals have intellectual property too. However, it's really important to know that business-related intellectual property should be owned by the business, not by the individual. So that's true even for solopreneurs, even if you're the single member LLC, all of your intellectual property should be held by your business because it is a business asset. So if you want to go to the next slide. So the types of intellectual property your business could have. You have your brand, so your name, your logo, your slogans, all of that stuff. You've got your products and services. You have your website, blog, podcast, brochures. You've got customer lists. You have methods and procedures. So all of these things are part of your business's intellectual property. But how do we categorize these? Well, some types of intellectual property can be protected by law in the form of government incentives. So for example, copyright protection is a government incentive. It's the reward for being artistic or creative. So copyright is any original work of authorship. So some examples of this is books, artwork, music, movies, architecture, computer software. So this is where you have your blog, your podcast, your videos, your photos, the content on your website. All of those things fall under copyright. So the next type of intellectual property is patents. And this is a government reward for inventing a new and useful invention. Examples of patents are devices, methods, product design, and plants. Patents last for 15 to 20 years. So it's the shortest term of all the types of intellectual property terms, I guess. And then finally, we've got trademark. And that's what we're focused on today is a trademark is a government reward for developing your brand. And a trademark can be anything that indicates a particular source of a good or service. So it can be your business name, your logo, your slogan, your product names. It can be a color, a smell. There's all different types of things that can be used as a trademark. And a federal registered trademark lasts for 10 years, but this is renewable indefinitely for as long as you're still using that mark. So the trademark potentially has the longest term of any of the types of intellectual property. So can you go to the next slide? And so now I'll go over patent briefly to give you a basic idea of what a patent is and how you can differentiate it between copyrights and trademarks. So there's three types of patents, and a patent, again, is a reward for sharing your ingenuity with the public. The first type is a utility patent, and this is the most common type of patent. It's really what people think of when they think of a patent. It's any process, machine, article, device, composition, and it lasts 20 years from the date of application. And so, for example, on the left of the screen, you see that's a drawing for a patent of an iPhone. So it's the device itself, the iPhone device. The second type of patent is a design patent. So this is an ornamental design. So this is anything that's non-useful, and it only lasts for 15 years. So the middle part, this is actually a design patent that was issued to Apple, and you may recognize it as the actual shape of the iPhone. So it's a rectangular shape with rounded corners. And if you wonder why no other, I mean, there's been a lot of litigation about it, but essentially, yeah, Apple did patent a rectangle. And then finally, the least common type of patent is a plant patent. And it's really a reward for people who are developing new strains of plants. So this is really uncommon. It's basically flowers, agriculture, and more commonly now, more popularly now, cannabis. So on the left, you'll see this is a photo from a recent plant patent that was issued last year. It's a strain of cannabis called Pan 2020. I guess it was named after the pandemic, and it has like certain chemical profiles that, you know, were deemed patentable. So that's three general types of patents. You can go to the next slide. So why should you file a patent application? Well, a patent, when you get a patent, what it really does is protects the assets of your technology-based business. You also can use it to establish the value of a company for funding or sales. So let's say you're a startup, you're looking for capital, and a lot of investors will say, okay, well, what do you have? And if you can point to a patent and say, hey, I filed this patent application, then they know what they're investing in. And the other thing is, unlike other forms of intellectual property, there is a deadline. So you have 1 year after you start selling your idea. Like, let's say you invent a device, you start selling it, you have 1 year from the date of first sale to file patent application. So if you're not really sure whether you should file it, go ahead and file it and then deal with it later, because you can't go back, 2 years later and say, oh yeah, I need to file that patent application. It's too late. The other reason to stake a claim in a crowded technology area, let's say you're working in some tech area that's really hot and you just want to, throw your hat in the ring, file a patent application, because you never know who's going to license it. And finally, bragging rights. I wouldn't recommend this unless you're independently wealthy. I've definitely worked with inventors who are independently wealthy and they just want to say they have a patent. So, there you go. There's all different kinds of reasons why you want to file a patent application. So the next slide.
So
is,
Phyllis, real quick, I have a question.
Sure.
So sometimes you'll see people, have something that says patent pending. Does that mean that they've filed the application, it just hasn't been approved yet, or
Exactly.
why would they use that language?
There are a couple of reasons. One is kind of a deterrent because it sort of tells tells everyone else, hey, this could result in a patent, so think twice about copying it.
Mm-hmm.
It also establishes, once the patent is issued, it establishes that you have given people public notice. And so then if somebody's infringing, you can reach back to before the issuance and say,
Mm-hmm.
hey, you knew that it was probably going to be patented, so therefore you can get profits off of
Sure.
an infringer that way.
Okay, great. Thank you for clarifying.
Yep. Sure. So the next slide is why you shouldn't file a patent application. And people say to me, Phyllis, you're a patent attorney. Why are you telling people to not file patents? Because that's literally your job. And the reason is because for a lot of businesses, it doesn't make sense to file a patent application. So for one, again, the patent is a reward for disclosing to the public what your invention is. And so that means you have to disclose to the public what your invention is. So if it's something that, and remember, it's only 20 years. The patent term is only 20 years. It's not extendable. So if it's something that you think is you're going to make more money for longer than 20 years, then you shouldn't disclose it, because that means everyone, after 20 years, anyone else can use it with zero repercussions for you. The other thing is, it's a lengthy process. It takes about at least 3 years from filing to issue, and it's expensive. So it's, $20,000, $20,000. So it only really makes sense, business sense, to do it if you can if part of your business plan is a return on your investment of that money. It's also complex and really difficult to DIY. There's a lot of stuff out there that says, like, write your own patent. And yes, you can write a patent, but it will not be a good patent. And that's why you really should hire a patent attorney. Like, there are other things where you don't need to hire an attorney, but this one, you really do need to. And then territory. If you're only selling in the US, you only need to file in the US. But if you have some sort of global market, you have to obtain a patent in every single country. And that gets expensive because each one is costs money. So now that I've convinced you to not file a patent application, what are the alternatives? Well, the first one is a trade secret. So the trade secret is good for items or processes that are difficult to reverse engineer. So a formula or a method or a recipe. So for example, my dad is a chemist. He created a bunch of different chemical processes, and I'm a patent attorney. So it would basically be free for him to patent these things. But we decided to just keep it as trade secrets because it's the kind of thing where, because it's a process, the end result, you can't really tell how the process was done. So it's easy to keep it a trade secret. And also, if he had patented it, then anyone could use it. And it's really difficult. It would be really difficult to prove that someone's infringing his process, because again, the end result is the same as if you used a different process. So trade secrets are unlimited in time. They go on forever, as long as you can keep it a secret. And that also requires affirmative steps to retain a secret. So like, let's say you hire somebody or you have an outside contractor, make sure, if you're trying to keep something a trade secret, make sure you have a non-disclosure agreement in place so that people know, like, hey, this is a secret. And the flip side is, if somebody independently creates the same thing that you have as a trade secret, or somebody gets your recipe and then, or they get your product and then they're able to reverse engineer the recipe, you really have no repercussions, unless they actually stole your secret directly from you. You can't go after them. So a trade secret is good up to a point. Another alternative to getting a patent, you can be the first to the market. So first actor can dominate the market until competitors catch up. This is advantageous for fields that change quickly. Like, for example, a fidget spinner. Remember when they completely flooded the market a few years ago? The person who invented it, if they had a patent on it, and I don't know if they did, they wouldn't have really gotten their money's worth, because they were the first to the market, they flooded the market, and then everyone else joined in. But do you really want to go after all of those independent manufacturers? I don't know. It doesn't really make sense to me to pay a lawyer to go after all of those, because the fad just, skyrocketed and then plummeted. And the other thing is, you can couple with trademark your brand reputation to retain the market share. So if you're the first one and you make the fidget spinner and it's called a fidget spinner and you brand it with fidget spinner, you can still create the market share without a patent by just saying, like, hey, get the original fidget spinner. And that sort of cachet really helps with the marketing. And finally, open source. Make your invention public. Just go completely public with it. What this does is it prevents competitors from patenting the same technology, and it just sort of blows the whole field wide open so anyone can innovate in that field. Okay, so what's really important, the flip side of protecting your own IP is also making sure that you're not infringing on someone else's IP. So this is important for patent and trademark, because both of those are what we call strict liability. So It doesn't matter if you knew something was patented or trademarked or not. If you're infringing someone's patent or trademark, you're on the hook. So it's really important to know what's out there so that you don't inadvertently start infringing. So for patent infringement, the way to avoid patent infringement is a freedom to operate study. So if you're doing something you have a tech-based business or you're selling some sort of product, it's a good idea to just do a quick patent search. Does this fall under anyone's patent? Because if it does, you want to kind of figure out how to not infringe that patent. And so you can do a quick and dirty on your own. You can hire an attorney to help you do that. An opinion from an attorney may protect against willful infringement. That's sort of a legal thing, but if you infringe someone else's patent and you don't know, it's still patent infringement. If you infringe someone's patent and you do know, you're in bigger trouble. So either way, you're in trouble, but willful infringement, you're in bigger trouble. So let's say you've got a process, it is covered by a patent and you're just like, oh shoot, do I need to rethink my entire business practice? Maybe not. So you look at the patent and you figure out, okay, what can I do slightly differently so it doesn't fall under that patent? So that's called design around. So that's when you configure your own product or process to avoid infringement of an existing patent. And that's true for trademark as well. You just sort of tweak something and then maybe you wouldn't fall under the trademark. And then most importantly, keep records. I'm an attorney and I'm just going to keep on saying this. Keep records of everything you do. So if someone then sues you, you can hold up and say like, hey, wait a second. I sent this email to my colleague that said, we were doing this way back before you had your patent. So, it's prior inventions. I'm fine. And then if somebody says, oh, hey, you can use my stuff, that's fine. Just get it in writing, send an email, send a text, keep a record of it, because you just want to have a record of any kind of permission that's given or received.
All right, thank you, Phyllis, for that great information. And we have some Q&A at the end, so she will be available to answer some of your questions. And feel free to put them in the chat if you have questions about anything that she's already spoken about. And next, we'll go over to Roland to talk about trademarks.
All righty. Well, let's see. Trademarks are basically the core of the protection that you can get for a brand. So let's see. I believe there's some legalese here on the slide. There we go. Okay, so the legalese, the definition of a trademark is a non-functional attribute of a product or service that can cause a consumer to associate that product or service with a source. In English, that means if it makes you think of a specific company, it can probably be trademarked. Okay, but it's designed to make you think of a specific company. Okay, it's not necessarily a feature of how the product works. It's an attribute that doesn't have anything to do with how the product works. If it does have to do with how the product works, then it's something that's the subject of patent protection. So painting a car red, red bottom shoes. We'll go with red bottom shoes because red bottom shoes, most ladies at least, immediately think of a specific company. But contrary to what police might think, red does not make you go faster. So having red bottom shoes is not a functional attribute. It doesn't change how the shoes function. It just serves to identify where they came from. All right, next slide, please. Let's see. So there are a couple, we can go with a lot of different examples of what really constitutes a trademark, right? You can trademark a product name. You can trademark a company name. You can trademark a symbol. You can trademark a shape, right? I don't know. I don't think I've ever seen anyone else use the Coca-Cola glass bottle shape. That's because it's trademarked. Pizza Hut, the roof is trademarked. Devices, slogans, sounds, color. Okay, we already did the red soled shoes, but even animations it is possible to get an animated trademark. Not that a lot of people do that, but it is possible. So there are a lot of different things that you can trademark. Next slide, please. Let's see. So we have it as a way of protecting basically your company's identity, but really protecting the consumer, right? So the consumer has, they expect when they see a certain logo, they expect to get a certain quality and type of product. And if you get something completely different, then that can hurt the consumer's expectations in the future. And so you want to make sure that if you get a Big Mac from McDonald's, if you go into a restaurant that has the golden arches outside, that number one will always be a Big Mac, right? And not something else. So the trademark is really kind of the legal side of branding. Who owns it? First person to use it. Now, you can actually begin to use it before you register it. What creates trademark rights is not the registration, it's the use. Okay, registration is just kind of putting other people on notice. Hey, I have been using this mark to identify my company. So date of first use is king. Whenever two trademarks fight, the one that has the earlier date of first use usually wins. But there's also a question of where, right? What right does the holder have and where? A trademark that when you just start using it is typically what's called a common law trademark. Okay, it only protects you really in the area where you use it. If you start using a specific name for your hot dog stand, it might only go for a couple of blocks. If you start using your company name and it's say a tech company in Reston or something, then you might be known through, you might get protection in Tyson's, you might even get protection as far as Arlington, but you're probably not going to have protection at the other end of the state in Roanoke unless you file a state trademark. State trademark is going to protect you pretty much throughout the entire state, but of course the gold standard is a federal trademark. Federal trademark is a national trademark, and then your mark can be recognized basically anywhere. The nice thing about a trademark is it lasts potentially forever. As long as you use it, then you can keep it, which is of course a double-edged sword, because if you stop using it because you think you're not going to use it anymore and then you change your mind 3 years later, oops, you lost your trademark. But theoretically, as long as you keep using it, it's yours forever. Copyrights. Okay. So there's some legalese here too. A copyright is protection for an original work of authorship fixed in a tangible medium. What is a tangible medium? With e-readers, we don't even know anymore. Anyway, it is so really there are three parts here, right? Original work of authorship fixed in a tangible medium. It has to be created by someone. It has to be something that they created that is creative enough that it takes at least a little bit of creativity to come up with it, right? It's not a recipe, for example, can't be copyrighted if it's just instructions. If you throw in some personality, if you throw in some, a pinch of this, a dash of that, or whatever, now we're getting into the arguably creative enough. But generally speaking, there has to be at least a minimum level of creativity to actually get a copyright. And then fixed in a tangible medium. You can't just say, well, that sounds like something that I had an idea about 2 years ago, but I never wrote it down. I never drew it out. I never actually put it somewhere on paper. There was a copyright case a little while back, more than a little while back, a couple of decades ago, where a fellow came and said, yeah, the AT-ATs, the walkers from Star Wars, the big four-legged things with the laser cannons on the nose, those are actually copied from my Garthian Striders, which I came up with a couple of years before the Star Wars movie ever came out. And so they asked him, well, can you prove it? Did you ever put anything down on paper? And I don't remember his exact answer, whether it was like, well, yeah, but I lost it, or whether it was just, well, no, I don't really have it. In any case, basically he lost because he couldn't prove that, yeah, he had actually put it down somewhere, that this idea had come before Star Wars. So, so what does that mean? You can have two entities that create the same works independently. And like Phyllis was saying, the better you document where you came, where these things came from, where your ideas came from, what you came up with, and when you started using it, the easier it's going to be to prove that, okay, this isn't something I just copied from this other guy. It's something I came up with myself. Next slide, please. Or, oh, okay, or more stuff. So let's see. Okay, so yes, so like trademark. Okay, so like trademark, just using stuff, just creating stuff actually creates your rights. You don't have to register it unless you want to sue someone, unless you want to protect it. If you just create stuff, if you write a novel, you automatically have a copyright on that. But you're not going to really be able to protect it to the next level, to be able to actually protect it legally, unless you register that copyright. And so, yes, along with that comes the circle C symbol. Next slide, please. So what are some examples of how you would use copyright in business? Potentially books, articles, surveys, forms, training materials, anything that you might create, documentation, right? If you write okay, so software programs are on here, but let's say that you have a piece of proprietary software, you write a user manual for it. That too potentially could be covered by copyright. Compilations of data, website content, advertising copy, blog posts. Also, if you're a photographer, right, then okay, obviously all of your pictures are protected by copyright. As long as you took them. There was a case a little while back where a photographer was out in nature and a chimpanzee got his camera away from him and took a picture of himself. It was the chimpanzee selfie. And there was a big copyright fight over, okay, wait, who owns this picture? It wasn't taken by the photographer. It was taken by the chimpanzee. So yeah, so interesting questions there, right? Next slide, please. Or, oh, okay. So why do we have copyright? We want to encourage the creation of more art. We want basically people to create stuff. So by default, the creator of the work owns the copyright to something that they create, unless there's an agreement, right? If you work for Walt Disney, chances are the stuff that you create is going to belong to Walt Disney. If you're an independent contractor, it belongs to you by default, but there will quite possibly be a clause in the contract, and this is where having an experienced attorney to look over your contract will help you. Unless there's a clause in the contract that says any IP that you create belongs to me. And so there are a set of rights. Really, copyright is kind of this bundle of rights. You get a bunch of different things that you can do, right? Copy, distribute, display, perform, use, make derivative works, all of these kinds of things. And you can, when you own the copyright, you can license out all of those, some of those, none of those, whatever, it's up to you, but you get to decide basically how people can use your stuff too. And copyright lasts for a long time. It lasts for the life of the author plus 70 years, unless you're a company, in which case I think it lasts 95, but it lasts a long time. Next slide, please.
Before we transition, I just
Right.
wanted to ask about the idea of public domain. I know that word is used a lot with respect to copyright. Maybe you can just sort of clarify what that means as it relates to this topic.
Okay, so public domain essentially means that something was under copyright, but is no longer under copyright. So copyright lasts for life of the author plus 70 years or 95 years if it's a company. And then after that, the copyright essentially expires and something goes into the public domain. So right now, I believe works from 1923 or 24 are entering the public domain. Sherlock Holmes is a recent addition to the public domain. And that's because if you tick backwards, right, that's about 70 years plus or minus the lifetime of an author. So when something is in public domain, now you can take it and you can create your own works using pieces of it, based on it. You can duplicate it in its entirety and publish it, whatever you want to do with it, right? If you want to put your own spin on Cinderella, the reason you can do that is because that story is in the public domain. So let's see, copyright versus trademark. Both of them deal with words and pictures, but the attack, the angle that you take is different. So with copyright, it's more about I own this and it is something I created. Trademark is more about I own this and it represents me. It represents a part of my company, my company's identity. Next slide, please. So if we have time, I'd like to do a little bit of audience engagement here. Let's say that we have a company, you're a company, you're an entrepreneur, right? You own your own company. You hire a company to create your logo and they're willing to transfer their rights to you. So they create the logo and they're going to give it to you. What kind of rights are they transferring you? Copyright or trademark? Anyone want to take a guess?
I'm gonna guess copyright. That's my guess.
That's right. So the logo designing company, right? They're taking their artistic talent basically and creating a logo that they say, okay, this has some traits that are going to make a good impression, and it's something that we're creating to look good, and we're going to sell you the right to create and reproduce this image, this particular design, this particular logo, and they sell that to you. Next bullet. Okay, now you take that logo that they just sold you the copyright to, and you put it on your web page. It's your company logo now. Ding. What rights do you want for doing that?
Anyone can chime in.
I want the right to know that no one else can use that symbol and that it is going to protect me and my brand.
Okay. And is it copyright or trademark that's going to give you that?
I think trademark is going to give me that.
That's right. So when you put it on your website, now you're using it as a way of representing you, as a way of representing your company. And that is what a trademark does. It says no one else has the right to use this mark in association with you, with your company and your goods and services. Next bullet, please. Okay, now, a couple of years down the road, your company is big and successful. Everyone loves it. Everyone loves the logo. Everyone recognizes it. You want to sell your company, including the logo. What rights is the buyer going to want? Copyright or trademark?
It's a trick question.
Is it? Yeah. Is it both?
It is a little bit of a trick question. Yes, it's both. The copyright, obviously, they want the rights to actually display, use, create, reproduce the logo, of course. But they also want the right to use it as a representation of the company. So they want both the copyright and the trademark. And having both of those registered with the federal government is going to basically increase the value of your company. You're going to have assets, right? You're going to have something that you can sell in the form of this trademark registration, this copyright registration. You're going to have something you can sell to the buyer that's going to increase the value of your company. So next slide, please. Okay, next test. So there are some ideas that might not be protected, right? Ideas are not protected. It's the way that you express the idea, not the idea itself. So my boss's wife actually had this happen to her, okay? She applied to HGTV with a letter that stated, "I hate my kitchen." Then they started a TV show called "I Hate My Kitchen." What happened? Well, is it protected? Is it protected by trademark? Does it represent her or a company or a service or product that she provides? No, not really. Is it copyrighted? Well, it's not really that original, right? It's like, it's a statement of fact. There's no real artistic, like it wasn't a poem about how much she hated her kitchen. It's just kind of a statement, right? There was no real creativity to it. So it's an idea more than it is a particular expression of that idea, and it can't really be protected. Now, the title of the TV show, on the other hand, well, could it be protected by copyright? Probably not. Again, it's not that original. You can't usually protect a title anyway in copyright, but in trademark, possibly, because if they have like a whole series or something, then it could come to be known by that. The series could come to be known by the title, right? I Hate My Kitchen. So theoretically, it could become a trademark if you use it the right way. This is also, by the way, a piece of the genius behind the rock band Kiss, because you can't trademark your face, but if you paint your face and you paint it a certain specific way every time, now you can trademark that particular design and you can sell toys or whatever, and nobody else can copy them because they're trademarked. So next slide, please. So some frequently asked questions. Let's see. What are the fees associated with filing for copyrights and trademarks? Well, trademark, it depends on how many goods and services you provide. Generally speaking, the more goods and service, like the broader your offerings, the more fees you're going to pay. But for a relatively simple trademark, we at least talk about it being probably about $1,500 between government fees and attorney's fees. Copyright is going to be closer to $1,000 between government fees and attorney's fees, but again, that depends on how many things you want to copyright. What is the difference between copyright infringement and plagiarism? So there we have to kind of back up to who's doing the enforcing, right? With plagiarism, usually you hear about that in an academic context. It's someone who did research and didn't give someone else credit. Copyright has a couple of exceptions, okay? There's fair use. And fair use usually leaves out things like parodies, things like learning for educational purposes, and things like reproduction for research purposes. Okay, so if someone goes and they do research, it's probably not covered by copyright, but if they fail to cite their source, then it is plagiarism. Usually a university is going to be doing the enforcement of plagiarism. The government is going to be doing enforcement for copyright, right? If something might be plagiarism without being copyright, or it might be copyright without being plagiarism, or it could be both, or it could be neither. So if I see someone else using my mark, is it too late to file? Probably not. It depends. You're going to have to talk to a trademark attorney because there's a possibility that even though they're using your mark, they haven't filed to register the mark that they're using, which means you might still be able to get an earlier registration. Now, the rights that you're going to get might not be as good, but they will, at least it's a foothold, right? Think back to Reggie's story. We did have to deal with this other company that had a trademark, a prior registration to him, because they had that prior registration. Theoretically, his rights are greater, but practically speaking, if it's going to cost you an entire lawsuit just to go out and get your rights from them, sometimes that's enough of a deterrent.
Yeah, maybe what, because sometimes people approach me with rebranding because they run into some of those types of issues where it's not worth it to kind of go through all the the legal filings and everything to try to they've maybe been approached with some type of action to stop using what they're doing, and rather than fight it, it's just easier to just kind of rebrand their operation, and go in a different direction. So I know that like there was a recent issue between like the XFL, which is like a sports league, and then another sports media company that they sent them like a cease and desist letter. I think that's really scary for small business owners to get some type of notification like stop what you're doing, from a law firm or something like that. So it can be, I just know, being on the small business side of it, nobody sort of wants to be in that situation. But maybe you guys can share a little bit about, okay, let's say you get one of those things in the mail from a law firm, like what should you sort of immediately do? Because that could just be, very shocking and scary. You're just trying to run your business and you get notified by that about that. So what are some things that maybe like a small business owner should do in the event they get some type of legal notification like that?
Okay. Take a deep
Call
breath
a lawyer.
Yep. Call a lawyer.
Don't.
Take a deep breath.
A really common thing is people get a letter and they're like, oh, shoot, I'm just going to take everything down. That's not always the best idea, because then the other person could use that as like, well, you knew you were infringing. That's why you took everything down. So don't do anything. Just call a lawyer.
Okay. Great.
Freeze. Yep, exactly.
That's really good advice. That's
Yeah.
really
I
good
mean,
advice.
It's so Phyllis and I both have practice of putting ourselves in the shoes of the other lawyer too, right? So there's also this cognizance of like, okay, if I act this way, what's that going to allow them to say? What's that going to make their story? Right. And that's exactly it. You want to be careful, because if you do something that whatever you do could potentially be used against you too. Right. The police warn you, you have the right to remain silent. Anything you say can and will be used against you. Well, it's not just the police. Theoretically, in any lawsuit, anything you say can and will be used against you. But that's why it's such a good idea to have a lawyer around, is because then they can say, well, it would probably be most reasonable if you just responded this way. Right? We're used to thinking in terms of the audience. What's the audience going to think here?
Yeah.
And Reggie, to your point about rebranding just to avoid the hassle, just a cautionary tale. Even if you have, as Roland said, you do have some trademark rights even before you file a trademark registration, a federal trademark registration. However, enforcing those rights, it's going to get expensive, because you have to pay an attorney to prove in court or before the trademark office that you have seen your rights. So sometimes it is just easier to say like, all right, I'm going to hire Reggie to do my rebrand because I just don't want to fight it. I know of a small business who went through that. They ran their business. They didn't have a trademark registration. Someone else in a different state started after them. They got their federal trademark registration. It wasn't even the same thing. It was, mildly similar. And so, the second company went after the first company and said, hey, you're infringing our stuff. And the first company was like, we were here first. The second company sued the first company. The first company actually won. However, what did they win? Well, they won the rights to continue working in a certain in a limited geographic area, and they won a $20,000 legal fee. I mean, lawyer's bill. Nobody wants to win that, right? So after all of that, they still had to rebrand because they wanted to expand eventually. So sometimes it is easier just to not fight it, especially for small businesses. If no one gets into small business because they want to get sued and they can't wait to fight in a lawsuit and pay their lawyer. So sometimes it is just easier to go ahead and rebrand. And that's another thing that Roland mentioned is sometimes you really, before you get your heart set on a business name and you got your website and all of that, just do a trademark search. See who else is using something similar. If enthusecreative.com is taken, so you think, oh, I'm going to be the enthusecreative.com. That's sort of a signal to you that maybe someone else is using the same name, and you should look into that further. So, when you're doing your social media handles or your domain name and you're coming across stuff and you end up having to do .net or .biz, it's sort of a signal to you that, maybe someone else is using something similar and you don't, for SEO, for SEO stuff and marketing purposes, you don't want to use the same name. And also for trademark infringement, you don't want to start your business sort of stumbling into a trademark infringement lawsuit.
Excellent. Well, we may have to do another one of these in the future, because I have some questions about in this sort of social media based world that we live in, people just steal images, they steal memes and GIFs, and there's a whole world of technology that, has made it very easy for people to create content, but also to steal content, to misrepresent, things that people say, or, pictures. There's deep fakes and all this kind of stuff. It's a whole world. So we may have to revisit this topic again and kind of focus on technology. But I think Arlene has a question. We have time for one or two quick audience questions before we wrap up. So you can go ahead and ask your question, Arlene.
Okay, thank you. So I have a question regarding patent. And I created a brain training system, right? Which helps people to relax. And I've been testing it, and I tested it on every continent, but I didn't put it out there to the full public to explain or expose them to what it is in its entirety. It was suggested by Johns Hopkins that I patent what I was doing, one of their professors. And so I am now going to file a provisional patent for it. And my question is, will I run into trouble because I've been testing it for more than a year?
Arlene, that's a really good question. So testing is sort of this gray area where it really depends what you mean by testing. If it means testing in that you're fine tuning your process, and after you do a series of tests, you realize, oh, steps 2 and 3 aren't really the way working out the way I'm going to change them a little bit, then that's okay. But if it's testing in that, you're still using the same process, you're just using it on different people to see the marketability and things like that, then that would create a problem. So really, that's a gray area. And, to be most conservative, I would say just whenever you kind of started using your final process is kind of when the clock starts ticking. And again,
Okay, so
make sure you have all of that records of when you did things.
Okay. I haven't done the final has just come into being. I thought I had the final, but the final has just come into being in 2022. But I started playing with it in the end of 2020, late 2020. So, okay.
Yeah.
All right.
And it also really depends on how you write the patent, because sometimes, the final process may be more specific and you want to patent kind of the more general process. So there's a lot of considerations there. So yeah, since you're filing the provisional, I'd say do it ASAP, because you don't want to run into trouble later on.
Okay. All right. Thank you ever so much.
You're welcome.
So we're right up against our time. So if there are any questions, this is our contact information. I want to thank Phyllis and Roland so much for the amount of knowledge and insight that they provided to us today. They're definitely experts in these areas. And so if you have a specific question or need to talk to them about, a deeper matter, feel free to reach out to them directly. So I want to thank all the guests who have attended. And this webinar will be recorded, and you'll receive a notification about the posting of the replay in the next few days. So with that, we're going to stop recording. Thank you, everybody, for coming. And thank you to our panelists. And I appreciate you all. Have a great weekend.
Thank you so much.
Thank you. Have a good weekend.
You too.